Advocate. I'm a reporter appointed by the Scottish Government to report to ministers in relation to objections to a compulsory purchase order at flat 3/178 Allison Street, Govanhill, Glasgow. This is a hearing into an objection by the landowner, Govanhill Limited. Govanhill Limited are a statutory objector for these purposes. They are the only objector to the order, but as statutory objector, because they are the owners of the property, a hearing to resolve or address the issues and allow them to be aired and hear all sides is required if asked for, and the objectors have asked for a hearing to take place this morning. So this procedure will take place and the hearing will proceed in the legislative framework, and that is for the compulsory purchase order, which is under the Housing Scotland Act 2006, and in relation to the Acquisition of Land Authorisation Procedure Scotland Act 1947, which is the procedure that sets out the provisions requiring this hearing. The hearing has been advertised by public notice in the Herald and the Evening Times, and as I observed on the site visit yesterday, by a site at the sign notice placed at the CPO subjects. I'll first of all ask parties to introduce themselves, say who they are, who their witnesses are, and what their interests are in this hearing, and then say a few introductory and preliminary words before we start the working through the agenda. And I'll start with Glasgow City Council, the promoting authority, who are represented by Amanda Cunningham, solicitor, on behalf of the council.
My name is Amanda Cunningham. I'll be representing the council this morning, and going from my right we have our witness, Eddie Ward, principal officer. The next witness is Anne Moran.
Okay.
Next individual, Ian McIntosh.
Yeah.
And Ulia Talk, another solicitor with Glasgow City Council.
Okay, thank you. And got recognitions from each of those three witnesses have been lodged in the process this morning. I'll say a bit about recognitions more in a minute. And for the objector, we have Mr. Thorburn, who I believe is the company secretary of Govanhill. If you want to introduce yourself, and I think you're there with a fellow director, Mohammed Zubair.
That is correct. I am the company secretary, and have with me Mr. Mohammed Zubair. He is relatively recently the both shareholder and director of the company, and so effectively the beneficial owner of the premises that are the subject of the hearing.
Okay, thank you. And I see that from the documents that have been lodged that he has become a director relatively recently. I think it was Razam Raza was previously a director of the company, but I'm presuming that he no longer has any other interest anymore in the company, and that Mr. Zubair now represents effectively, along with yourself, the two directors in the company.
Yes, Mr. Raza has ceased to be a director, so there is now only the one director, Mr. Zubair here.
All right.
I say I'm not a director. I am an officer of the company, but not formally a director.
No, that's very helpful to know that, just to can note down accurately what the various status is, so that as far as Mr. Zubair is concerned. And I've certainly seen from some of the documents lodged with the council the change in director arrangements from Mr. Raza to Mr. Zubair. So that's very helpful to clarify that. I've had no notification of anybody else wishing to attend. There may be others who are watching this. This has been broadcast live. But obviously for those who maybe have an interest in this and watching it, the only participants will be those who are in the room here just now. Nobody intimated to the case officer and DPA a desire to participate in the hearing this morning, so it's possible there's others who are watching, but no one else has been given call-in details for the call this morning, so I'm not expecting anybody else to be able to participate, though as I say, there may be other people who are watching. By way of preliminary issues before we start on the agenda, as I said, this has been recorded for DPA, and as is our norm within the DPA processes, the participants are taken to be consenting by their participation for the recording for the purpose of data protection and GDPR purposes. The recording will be available later if anybody wants to look at it on our website. The advantage, or one of the advantages of that, is it saves us having to worry too much about note taking, because the accuracy of what's been said, asked and responded to can be checked afterwards by parties if needs be. You can go onto the DPA website and anybody, by searching under the case reference, which is CPO-260-4, can access the recording of this hearing this morning. Equally, a number of documents have been lodged with DPA that are relevant to the hearing. We'll reference some of those this morning. I intend to refer to some of them, and parties may wish to as well. I've got some of them up on screen, but not all of them, able to access them. And if anybody doesn't want to refer to a document, we'll obviously may need to take a little bit of time just to give people the opportunity to get those documents up and on screen, so that we're all looking at the same documents at the same time. And as I say, access to those documents can be had by looking at the case management system, quoting that same reference, CPO-260-4. Various documents have been received. As I say, I won't narrate them all, but there's effectively 3 sets of documents submitted and on the case management system from Glasgow City Council, the first numbers of which are indicated by appendix numbers, but there were some emailing and various policies also submitted at various stages. And as I said earlier, 3 precognitions on behalf of the 3 witnesses for the council this morning. I have no documents on behalf of the objector beyond the letter of objection of 18th of March 2022. There are no statements from Mr. Thorburn or Mr. Zubair, but that accords with the procedural timetable and arrangements indicated before. As objectors, I did not require them to lodge a statement. They're just entitled to come along today, ask their questions and speak about the objection. But I have no intimation of any witnesses for the objectors other than those present with Mr. Thorburn. So the procedure this morning is by hearing. This is not a full public inquiry, so there'll be no cross-examination of witnesses. I'll be taking the 3 precognitions that have been lodged for the council as read, so I'll not be asking the witnesses to read out the precognitions. The main purpose of those precognitions is to give an indication of the evidence of those parties and indicate who relevant questions are to be directed to, and indicate their involvement previously with this property. My intention, although this is a formal hearing, is to make this as informal and relaxed as possible. I know that for many involved, maybe not the lawyers to the same extent, but for others, this is probably a relatively unfamiliar procedure to be involved in. And so if any party is in any way confused or unclear, or is not understanding what's happening, or has any objection to anything that happens in the course of the procedure this morning, just say any time, just put your hand up or shout, and we'll try to clarify that. And as I say, we'll try to make this as relaxed as possible. Strictly, the position is as chair of the meeting, all questions would go through me. But in fact, at the end of the day, I tend, as long as people are respectful and sensible, I tend to be quite relaxed about how we explore the issues that the objectors have and questions I have. And so again, I'll endeavour to be fair to all parties, to give them an opportunity to ask those questions, and we can play that as we go, both Mr. Thorburn but also Mr. Zubair as well, if he wishes to ask any questions at any time. On the basis that these are still relatively new ways of proceeding and doing business through virtual meetings and Zoom calls, we recognise that they can be quite tiring and quite intense. We have 3 hours set aside for this morning, although we can take as much time as is needed. But my intention is to take a break at around 11:30, take a short break at 11:30, just for comfort or other purposes. If anybody wants a break at any other time, again, they should just say. I'll say at the end about closing submissions. I'm not looking for parties to give closing submissions at the end of today's proceedings. I'll say a little bit about closing submissions if people want to make them, and there's no obligation to make closing submissions, but if you want to, I'll say a little bit about them at the end, but just to assure people that I'm not expecting a summary of their case during this hearing. I'll be setting a time scale mindful of the Christmas period for closing submissions. And lastly, by way of preliminary issues, and I say for the record that I attended the site yesterday to carry out a site visit in the presence of the Glasgow City Council, or certainly the Glasgow City Council official, two of the witnesses today, and the lawyer acting for the council, and was present Mr. Thorburn, and for some of the time Mr. yesterday. I don't know whether there were any issues, and I'll go to the council first of all, then Mr. Thorburn. I don't know if there were any issues arising in consequence of the site visit yesterday that we need to address before we start our formal session. We'll talk a little bit about the site visit and what we saw as we go. But is there anything you wanted to say further to site visit yesterday before we get started? To the council, first of all.
Oh, no, sir, there isn't anything further to raise.
Mr. Thorburn, anything you want to say?
Not at this stage. Not at this stage. Thank you.
That's fine. Well, you can reserve judgment. We can talk a little bit earlier on. Circulating an agenda, which is a very rough agenda. I mean, it's broadly what I'd want to the order of taking things through. There've been no suggestions of amendments to it, but again, how we deal with matters arising from the agenda, and some of them might end up merging into each other, we'll just deal with as we go. But I'll stop just now to ask whether anybody has any comments on what I've said by way of preliminary issues or on the agenda before we get started, and starting with the council again.
I think there's just one small issue I'd like to raise. I know Mr. Thorburn this morning said that Mr. Raza is no longer a director. I think that's correct from the paperwork that has been lodged. However, this morning on Companies House, Mr. Raza is still listed as a shareholder of the company. So I don't know, there's obviously two shareholders, the new director and Mr. Raza. So
my understanding is that when there's a change of an officer of the company, that is immediately recorded on the Company House website, either a director or a company secretary. Shareholding is not instantly uploaded. It's something that is maintained in the records of the company itself. But every year, the company has to submit an annual confirmation statement. And at that stage, that's when shareholding is updated on the public register. I think there is one proviso to that, and that's something that we probably have to think about. I think there is now an obligation to register persons with a significant interest, is it called? There's a formal name for it. Yeah. Somebody who holds more than 25% of the shareholding. And I suspect, the comment has kind of reminded me of this, I think the company probably, if, as I understand it, all the shareholding has now transferred to Mr. Zubair's name, I think now he would have to be registered as the person holding that significant interest. So that is something that we should be doing. So yes, thanks for the comment. But formally, the position is as I said, but we still have to show that, disclose that on the public register.
Okay, that's helpful. I mean, from my point of view, the main thing is just to ensure that Mr. Raza has no separate interest in the company and in the property that might require him to be represented in this process. I think, Mr. Thorburn, you're representing, as company secretary, you're representing the company as a whole. Mr. Zubair is obviously present as a director, but I don't think you're saying to me that Mr. Raza has a separate interest that needs to be represented other than what you're about to say this morning.
I think that is correct. That's certainly my understanding, that Mr. Raza has no separate interest. His only interest was as director and shareholder, but he has passed all of that to Mr. Zubair now.
Okay. Thank you. So, Ms. Cunningham, was there anything else about your preliminary issues?
So,
No. And so, Mr. Thorburn, same question to you. Is there anything unclear in what I've said by way of preliminary issues, or anything else you want to say before we get started with the agenda?
No, I think we're ready to go.
Okay, that's all fine. Thank you for that. Yeah, it just takes a few minutes to work through some preliminary issues so that we all know what the kind of layout and format for today. So I'll start my first set of questions that are addressed to the council, and that'll be their lawyer or witnesses as they think fit. And feel free to bring in your witnesses to answer individual questions as you think fit. And I've got some specific questions, but I wonder if you just maybe give a sort of summary overview. I know it's set out your statement of reasons of what the overarching justification for the order is. I know you're citing Housing Act powers in all of this, but it'd be useful just to kind of get a kind of sense of the essential case for my benefit and Mr. Thorburn's benefit of the justification for the order.
The order is promoted under Section 9 and Section 10 of the Housing Scotland Act 1987 for provision of housing accommodation. And really, this order will bring an uninhabitable property back into use, contribute to the supply of the social housing accommodation stock in Glasgow. The order is consistent with both the local and national housing strategies and the Scottish Government's Homes Fit for 21st Century Strategy and Action Plan for Housing included empty homes being brought back into use as an important contribution to their first strategic objection to build new, high-quality, affordable homes, which included social housing, to meet the current needs and demands for a growing and ageing population. I won't refer you directly to the policy, but it's just page 17 of the policy if you do need to refer to it.
Thank you.
Glasgow's
which policy is that? That
is the Scottish Government's Homes Fit for the 21st Century.
Thank you. Page 17. Thank you.
Glasgow's own housing strategy 2017 to 2022 details the key messages from the housing needs and demands assessment, the second one that was completed in May 2015. That's at page 9 of the housing strategy.
Okay.
It confirmed that meeting the housing needs and demands of current and future households in the city is reliant on achieving a sustainable mix of good quality and accessible housing of different sizes and types in both the existing and new build housing stock. And it confirmed that parts of Glasgow are going through a process of major regeneration to tackle significant levels of deprivation and to improve and or replace poor quality housing stock to meet needs in a sustainable way. The housing strategy also sets out its strategic priorities to include maintaining and improving existing housing stock. I'll just make reference to the page.
So your page, you've just quoted from page 9, I think, and then moved to page 15.
58, sorry.
All right, okay. Now, what am I looking at? I was looking at, hold on a second. Well, this comes up. I was looking at the strategic plan, but you're looking at a different document, are you? Housing strategy.
Sorry,
Housing strategy.
Housing strategy 2017 to 2022.
That's the reference to page 9. And now you're moving to page 15.
58, sorry.
58, sorry, but yeah, you did say that.
Oh.
Okay. I've got that.
That's it. That the council would take action in respect of properties below tolerable standard or at risk of becoming below tolerable standard. It highlights that long-term empty homes are a highlighted problem in a time when housing demands in all tenures are high.
Okay.
Glasgow's empty home strategy 2019 to 2022 sets out.
I just want to make sure Mr. Thorburn's keeping up with this.
Sorry.
If we're moving on to another document. Looking at the housing strategy there.
Just moved on to
Yes.
Glasgow's empty home strategy.
We're now moved to Glasgow's empty home strategy. Okay.
It sets out the council's 7 key aims. It also sets out the benefits of bringing empty homes back into use to meet the Scottish Government's Housing to 2040 vision, to bring the wasted resources of an empty home back into use.
And what page is that on, that reference?
Is
The empty home strategy. Big what's it again today?
Page, the empty home strategy, the aims are on page 6.
Page 6. Okay.
Council aims to work with owners to bring homes back to acceptable standards, and where that has been ineffective, the council will consider the use of compulsory purchase orders.
Yeah.
Focusing on the property in question, this property has been assessed as below tolerable standard.
Can I, just before you go on to the individual property concerned, I just want to refer in that same document, the empty home strategy, and I'm doing this because I'm going to give Mr. Thorburn an opportunity to respond to what you're saying just in a moment. But I've noted in the empty home strategy at page 15, bottom of page 15 and on to page 16, there's a section about the use of compulsory purchase powers. And I was wondering whether you want to say a little bit about that. In terms of that relevance, the relevance of that at a kind of a strategic policy level.
I would say obviously in this case, there has been a refusal really to engage with the council. So really we've reached the end of the road as in being able to engage with the owners of the property. They haven't taken steps and really to try and have a positive impact on the property, to try and have a positive impact in that community. We do need to take steps to kind of reduce the incidence of antisocial behaviour and bring that property back into use.
Okay. And just lastly on the policies, I noticed that 3 of the policies run from 2017 to 2022. We're now obviously approaching the end of 2022. Is it the council's position that they remain the relevant policy documents? They've not been superseded as yet by subsequent policies. They are the up-to-date position, I presume.
These are the up-to-date policies.
Okay, thank you. Okay, do you want to then go on to the impact on the individual property, and then I'll give Mr. Thorburn a chance to comment.
Well, this property has been below tolerable standards in terms of Section 85 of the Housing in Scotland Act 1987 and has been prohibited for use for human habitation by the serving of a closing order on the 15th of October 2015. Since this enforcement action took place, the property has remained as below the tolerable standard. The previous owner of the property did not give any undertaking to bring the property up to a tolerable standard and had not satisfied the council that the property had been brought up to a tolerable standard. Govan Hill Limited became the owners of the flat in January 2017. Since January 2017 to date, the property has not been brought up to a tolerable standard. Council have had to carry out further works at the properties and statutory notices have been issued in terms of Section 80 of the Public Health Scotland Act 1990. Council have done everything it reasonably could to encourage the owners to restore the property to full occupation. Final request for a schedule of works was sought on the 14th of September 2021. And that's over 4 years since Govan Hill Limited became the owners. The schedule of works was provided or has been provided since. The council's position is that it believes it has allowed a sufficient period of time for the owners to engage and have the property repaired to a tolerable standard. They have failed to do so, And there's no evidence that it would now, nearly 6 years after taking ownership of the property, attend to the repairs. It makes the order is necessary because it will allow the property to become an affordable social rented property that will assist in meeting Glasgow's housing needs.
Thank you. Now I'm going to go to Mr. Thorburn just now to give an opportunity to comment just in response of what you've heard. We'll go in a little bit more detail later on, in more detail to your objections. So you will get a full chance to talk about that. And I've got some questions for the council on what they've just said. But I'll go to Mr. Thorburn just now to ask if you've anything to say in response to what's been said about the overall policy context, or ask any questions of the council officials that are here just now.
Yes, sorry. The policy background is I think generally understood, and it's there's certainly no suggestion from the objector's point of view that there is any issue with that policy, but it's quite clear from the remarks that the council's representative has just made that there is a very stark difference in perception, not in relation to the kind of background, but in relation to the relationship, shall we call it, between the owners of this property, past and present, and the council as a sort of regulating authority. That, I think, is what you're suggesting. We will deal with the detail of that later.
Sure.
Certainly, there is not a dispute over the existence of, for instance, the fact that, yes, a closing order was issued in October 2015. There's not a dispute that the property is not in a condition that it can be or should be occupied as it stands. So that's not going to be an issue in principle. There may be differences in perception about the actual condition, the extent of the challenge, shall we call it, that the property presents. But again, I think these are things that we will deal with in more detail
shortly. Yeah.
Okay. Thank you.
Okay, that's fine. Well, I'm going to ask just one or two more specific questions. And my questions really to the council is, I'm keen to get a really clear idea as to what are the factors that are thought to be relevant for the purpose of compulsory purchase, and a number of other factors that have been made available really in the productions that have been lodged. The statement of case has very much been a focus on the kind of housing dimension, but I want to be really clear from the council as to what the sort of factors that are relevant. And so I'm conscious, for example, there's some issues arising in the past about abatement notices. And I know there was a problem around pigeon infestation, though that seems to have been addressed, and an abatement notice in relation to environmental health matters. Specifically on that question of the abatement notice and the like, what I'm not seeing from the council's justification is anything specifically saying what the position of neighbours are. Now, it's possible there have been complaints, and I know that the abatement notice related to questions of smells and the like. Now, it may be that there's nothing put before me in relation to the neighbours, because that's just not relevant. So it'd be useful to just get a sense of whether the environmental protection notices, are they relevant to the CPO? If so, why? And if so, is there anything you can say about the position of the neighbours, or is the abatement notice, although it's shared with me, or is the abatement notice in fact relevant to the council's justification?
think I could take this on, Mr. Cockett.
Of course.
Obviously, the main major reasons, apart from housing, as we explained in terms of existing housing policies, are the property being an empty home, which is again a massive policy aim of the government and the council. Secondly, the property being applied on the neighborhood, and that is due to environmental factors, as you mentioned, and as we mentioned in all the documentation already submitted, but also due to crime, antisocial activities at the property, which were recorded, and police records and council records. The neighbors have not been called in this hearing, but they were indeed involved in the process of dealing with this empty home by reporting various activities at the property to the police or to the empty homes officers of the council and asking for support. So that is evidencing the blight that the property is on the neighborhood. Two matters that actually may have been overlooked in our statement of reasons is that the Glasgow City Council has a governance strategy going forward, where again, housing matters and properties such as this one are to be dealt with by the council in a appropriate manner, such as encouraging owners to repair their properties, to bring them back into use and have them occupied. There is also the enhanced enforcement area, which was indeed submitted as additional information.
Yes.
So that is, again, something that the council is bound by, has applied for to the Scottish ministers, and now is bound by. So I hope this answers part of your.
Yeah, sure. No, that's useful. I mean, in context, I'll maybe refer you. I think I said in the email issuing the agenda that I may ask questions about Planning Circular 6/2001 on compulsory purchase orders. And the reason I'm asking these questions is in that circular, the circular says, I'm now going to read out from paragraph 26. It says, a local authority has compulsory purchase power that it may use to assemble land for housing and ancillary development. And there's a footnote there that says, when using housing powers, the authority should carefully consider whether it proposes to do anything that is not ancillary to housing. And so there's a recognition there. And I'd like to just go through some questions from my point of view that there's a power for bringing the property effectively into productive use. But I'm also conscious that there are already anti-nuisance powers. I think it's probably Environmental Protection Act 1990, assuming that those are still where the powers are. You've mentioned already the enhanced enforcement area regulations, and I think that gives the council powers approved by ministers to address issues of overcrowding. You've referenced the closing order. Assume the closing order is still in force, but you've got powers to against a breach of a closing order. There's been documents lodged that are relating to the repairs notice, but again, you have powers in relation to the repairs notice, and there's been reference in some of the precognitions, and as we saw on site, to criminality in the past in 2019. My question really is, all of those, and maybe ASBOs as well, I don't know if ASBOs still exist, all of those are things where the council have other remedies. They have other ways in which they can address these problems. I mean, I don't know more widely within Glasgow, but it was suggested yesterday and in recognitions that the property has in the past been used as a cannabis farm or whatever. But Glasgow City Council are not taking compulsory purchase order of every property in Glasgow that's used as a cannabis farm. So my question really is just, I want to be really clear. There's a range of powers, of issues, but you've got powers already to address these things through other means. So my question is, why a compulsory purchase order?
The answer to that is, indeed, the council is fully aware of other enabling powers for compulsory purchase for this property. But the main reason for that is funding of the project. The sections 9 and 10 of the 1987 Housing Act offer us wide enough housing powers to include this empty home, as we consider it to be, into the empty homes budget. That would allow the housing association to take it on, repair it, and bring it back into use, keeping in mind that Glasgow City Council does not administer its own properties, its own housing.
Okay.
So we do have to pass this on to the registered social landlords. So as opposed to other local authorities in Scotland who may consider all other enabling powers that you mentioned, Glasgow City Council has chosen to make use of these two sections of the Housing Act.
Sure.
In order to bring this project to fruition.
Yeah, okay. So that's very helpful. So, I mean, my question still remains to a certain extent, why this flat? I mean, there's others, and I know the council, I've seen from one of the documents that's lodged that steps have been taken in other houses for other properties, one indeed along the road in Allison Street. So I'm interested in, looking at these broader issues and some of the wider concerns in the local area and elsewhere. I'm still interested in why this flat? Why this one in particular?
There are several flats indeed in that area that are currently being compulsorily purchased by the council. Each order will only address one flat, unless all flats in a tenement are
Sure.
to be CPO'd. So why this flat? It is because its turn has come, because all our options have been exhausted. All the steps that could be taken have been taken, and because it is an empty home, because it is a blight. That's why. I don't think there is more to say to that.
Okay, now I'm going to go back to Mr. Thorburn, Mr. Surveyor. Sorry, before we finish.
For Mr. Probert. There are basically two triggers for the compulsory purchase order under the Government Hill strategy, and that is the property condition and the property needs to be an empty property. So as this was reported as an empty property a long while ago, it qualified for consideration for an order following full engagement with the owners.
Okay, I'm going to bring in Mr. Thorburn and Mr. Zubair, either just for a response to that, or if you've got any questions from the council in this question or this issue, other powers and why this flat as opposed to others. Do you have any observations or questions, Mr. Thorburn?
I think it's raising quite a lot of issues. In a way, it's perhaps touching on the second ground that I put in as an objection,
Sure.
the question of the conflict of interest. I will speak obviously a lot more about that once we come on to that point.
Sure.
I'm not sure that there's anything I need to say at this point. I understand your interest in this, and I may have some points. I think I will just hold off
That's
for
fine.
comments at this stage. I don't think there's anything that needs to be said at this point.
Okay, no, that's helpful. That's fine. We'll come to that. We'll give you a chance to make comments later on. No, that's fine. Thank you. Thank you for that. Just looking once more. I referred a moment ago to the circular, and just to reference also, so that parties are aware, Mr. Thorburn may want to reference this later on, at paragraph 29 of the circular, and I just read this out. The authority may be able to justify acquiring an empty property where there appears to be no other prospect of being brought back into residential use. However, it should be satisfied that it has first done everything that it reasonably can to encourage the owner to restore the property to full occupation. It may also be able to justify using housing powers to acquire a substandard property in some cases. So again, I just referenced that paragraph 29 is in my mind in that respect. One last question on item 1 for the council. We'll speak a little bit later about the condition of the property. In the statement of reasons, there's reference at paragraph 1.5 to water ingress. For those who were present at the site visit yesterday, I just say I wasn't sure that I specifically saw some evidence of water ingress, but it may be that those were issues that may be applied. It was possibly the flat below that suffered the water ingress. Or whether that's been repaired. But I don't know if council officials, maybe more than the lawyers, want to say anything about water ingress. There wasn't anything obvious that I saw, but as I say, maybe the flat below the problem for water was on.
The flat below was experiencing water ingress from the defective window sills in flat 3-1.
Right.
The abatement notice, council we abated that notice by instructing the repairs. There wasn't much damage in flat 3-1. It was travelling down the way, so that has been resolved, and the notice abated by the council.
That's fine. Yeah, that's helpful. I'd rather assume that was the case, given that water tends to flow downwards rather than upwards. That was the case, but I just wanted to record the fact that that on the site visit, I myself didn't see within this flat water ingress. Okay, now I want to move on to item 2 in the agenda, and that's just the position of the title position. We've talked on this a little bit already, and I'm mentioning there. I see from the title sheet the ownership is on title GLA 77811, which is lodged as a council production, and I just welcome views, first of all, from the council, although Mr. Thorburn may be able to enlighten me a little bit further on this as well, is on the title sheet, there still appears to be an undischarged standard security in favour of Eastern Finance International Limited that was registered in 2011. I know that as a security holder, they're therefore not an owner or a tenant or whatever, but that security doesn't appear to have been discharged. And so I'm just keen to make sure that there isn't an interest in the Eastern Finance International Limited still in the property for whom regard needs to be had. So maybe you could talk me through the steps taken and assurances ministers can have that there isn't a third party interest that needs to be given regard to. As I say, there doesn't appear to be a discharge of that security. Security in 2011 granted by Sally Chowdhury to Eastern Finance International Limited.
Yes, absolutely. In terms of acquisition of land authorization procedure, Scotland Act 1947, the acquiring authority, the promoter of the order, is not under an obligation to notify the heritable creditors of the making of the order. the council notified all persons with an interest in the land and advertised the order in accordance with the compulsory purchase statutory provision.
Yeah.
The creditor, any heritable creditor is notified on confirmation of an order by the Scottish ministers and are invited to make a claim for their loss. So the current registered creditor, that company registered abroad, will be notified by the council in the event that this order is confirmed. As it is now, they do not have an actual interest in these proceedings. They will be able to claim their loss if the order is confirmed. Otherwise, we do not think they would have a say in these proceedings. If there's anything further.
Okay. And certainly, if they're notified in due course, I mean, I understand what you're saying about the advertisement of the order. I would observe that the company has a registered office in Pakistan. It might be quite difficult to expect it to be aware of the making of an order in Glasgow, unless its officers are particularly assiduous in checking these things. But I hear what you say about the notification of confirmation in due course. But Mr. Thorburn, do you know anything about the status of that security? Obviously, you bought the property and you bought it, or your company rather bought it, or the company rather bought it subject to an outstanding security. Is there anything you can update us as to whether there's still money owed under that security?
Certainly, the understanding of the company is that the security is live. That there is it is still there for a continuing liability from the company. There is a known channel of communication. My understanding is that the creditor is aware of the CPO. It has not taken any particular part in it, but we will certainly inform them of the outcome of this procedure. For instance, they are aware that basically where we stand. I cannot give any specific details because I don't have them of what the claim might be, but that's really something that they would need to work out for themselves if we get to that point.
Okay, thank you. That's helpful. And aside then from that issue, the position in terms of anybody else with their interest, I think as the lawyers for the council are saying, that effectively they're confirming to me that from their due diligence and the best of their understanding, they're confirming that there's nobody else with an interest in the property had been identified who might have any interest in the title, other obviously than that security holder which we're talking about and the objector. I take it that's the case.
Sorry.
Addressable to the council.
Yes, that is the case. Thank you.
Yeah. Yes, it's the council's obligation, just in case there was other interests, which obviously you as objectors are not necessarily aware of. So hence the question addressed to the council to make sure that there's nobody else with an interest in the property that we need to be aware of. And my last question on title, and we spoke a little bit about this at the site visit yesterday, is I'm proceeding on the basis that there's some separately owned garden ground, or at least a share in the garden ground to the rear, but I'm proceeding on the basis that it's not a realistic option to limit the compulsory purchase to the flat itself. It's necessary to take the additional share in the garden ground, even though it's not the garden ground that's substandard, but I'm assuming that parties are agreed that the minimum land take is the right in the flat plus the garden ground, and it shouldn't be severed or separated out. I think Mr. Thorburn indicated that on the site visit yesterday, but I take it that's the council position as well.
In terms of the title, it is not clear. There is no such thing. There isn't an exclusive garden ground belonging to the
Sure.
flat. There is the common ground, and the order is promoted. The order will not exclude any burdens. All the burdens in the title are preserved. Therefore, none of the other owners in the tenement are affected by it. In fact, the general vesting declaration would act as a normal disposition, a transfer of title from one owner to the other. All the burdens are preserved. The only effect of the order will be the automatic discharge of the standard security, which happens automatically, but that is catered for by us contacting the heritable creditor.
Okay. Yeah. No, I understand there's no exclusive right to a garden, but it's a shared interest in that. But I think we're proceeding on the basis that it's slightly all or nothing for the flat. There's no sense in doing anything different in this circumstance. I think Mr. Thorburn, I think you indicated that yesterday. Makes sense. Okay, on that basis, my third item on the agenda was just confirmation about the timings of funding. And I know the council are not intending to carry out the work if the order is confirmed themselves. But I think the guidance indicates that there should be funding within 3 years of confirmation for this work to be carried out. And I've seen the preconditions that are indicating statements along the lines of funding being available, but it'd just be useful to have confirmation that it's anticipated that if approved, the work would proceed within that framework of 3 years. Yes. Okay, thank you. Mr. Thorburn, do you have any questions about funding?
Not really. Not.
Okay. All right, thank you. Right, okay. I'm now going to go on to the two grounds of objection. And I'm happy to deal with this, Mr. Thorburn. This is kind of your bit of the meeting, really. Whether you want to say something about the general background and context, first of all, or whether you want to just go through, as I say, I've split the objections out as I saw them, and as I say, they're based on your objection email of the 18th of March of this year. So I'm very happy to go with however you want to present your case. As I've split it into prematurity and conflict of interest, but and I've got one or two questions about your email, but I guess it's over to you. And I know you want to say something about how the difficulties you've had getting access to the property, etc. But kind of over to you really for your anything you want to say and consequence questions for officials.
Okay. Well, I think this is the point at which I have to admit to having made a bit of a mistake, a bit of a blunder here. You sort of summarized the two grounds as premature, that the order is premature. I think I put it as unnecessary, and secondarily as a conflict of interest. And rereading the way I expressed that, I have to say it's put very, very gently, very mildly. And that was in the context of having effectively come into this, become aware of the property, having had involvement with the property relatively recently. There's reference in the statements from the witnesses to a visit that I made back in October of 2021.
Yeah.
And it was really, I had certainly had some discussions with Mr. Raza, the previous director, I think on a number of occasions before that, when he had sort of just been effectively clearing his mind with me, sort of exchanging ideas about how how this property would be dealt with. Basically, his issue was getting access to the property. And I have to admit that I made a huge assumption. And I was aware of the closing order. And I was told in no uncertain terms by Mr. Raza about the security arrangements that the council had installed on the premises. And when I made my visit in October of last year, I saw that, and we saw that yesterday at the site visit. The assumption I made was that security arrangement was all effectively part and parcel of the closing order, that the authority that the council had to grant the closing order included powers and authority to effectively invade the private property of a third party, which is what we have here, and effectively stop access. Now, it was relatively recently, when I was starting to prepare for the hearing today, that I was thinking, okay, whenever you have powers to a statutory authority, there are procedures, there are rules for notification and objection and so on. And it was the thought that how do we go about challenging and reversing or altering this arrangement? Then I thought, well, where are these powers? And I looked at the Housing Act, and I couldn't find anything there. I looked at the Building Act, and I couldn't find anything there. Although it does appear to me that the justification that the council are using for having that security was to keep. It was based on having on the danger in the building, but frankly, that just doesn't fly. For practical reasons, but I'm sure the council officials will be well aware of this, that if the council, it does have powers to protect the public under the Buildings Acts, but there are certain quite clear procedures to be gone through. They have to give notification. There are opportunities for work to be done. And so on. There's a whole usual rigmarole. Now, there was never been any reference in any of this that I have seen, and I've seen more from paperwork coming through recently. I didn't have before access to all the emails and so on that have now been produced. But there is absolutely nothing in any of that to the Buildings Acts. So I come back to the conclusion that I can see no authority, legal authority, for the council to actually prevent the owner from having access to his own property. That now, it's effectively a question to the council. Can they produce authority? There is nothing that they have given us that I can see in any of their paperwork that gives them the authority in a situation like this to prevent us having access. They have been very, very clear that they have always had conditions for us to have access. We have to ask, we have to give our reasons. For tradesmen, we have to make up lists of work and so on. So we are not given free access. There's various quibbles in the paperwork that we can come to if need be. They're saying that access was never denied, but my problem is not denial, it's restriction. And since, I think, is it September 2019 when this was put on, effectively we have not had the access that an owner of property normally can expect and should have, except through the council. And that has had huge practical effects. But the practicalities are almost by the way. It is the principle of this thing that the council, as I see it, has taken action that it has no legal authority to do, and now it is trying to benefit from its own, well, I can call it misconduct. It certainly, if it's unauthorized, it is misconduct. It may or may not be an innocent error. One assumes that it was, but it is now seeking to benefit because our lack of access has now given them, as they see it, the grounds for going forward with a compulsory purchase order, which, in my view, is rewarding them for something that should never have happened in the first place.
Okay, thank you. So you'll have more to say. Shall I go back to the council just now? I think on the question you were asking for them on the closure order. I know this is a whole continuity of issues, the one leads to the other. They're not unrelated. But I give the council opportunity to comment on that specific question that you're seeking some enlightenment on. That is the powers to restrict access under the closure order or other powers.
Yes, indeed.
Going back to before the door was put on the property, obviously Govan Hill Limited owned the property since January 2017. Prior to the door being put in place, there was several incidents that occurred. There was a reference by the police to a cannabis farm in May 2019. Then at a subsequent meeting, it was reported that the property was occupied. It was at that stage flat 2/1 had been impacted by water ingress from the property. From around July into all of August and early September, the property was being occupied illegally because of the closing order. Mr. Raza was contacted regarding the occupation of the flat. I believe in one of the emails, I think it was in the additional information one.
Yeah.
Mr. Raza advises that the in question is not rented or leased, or a lease hasn't been issued to anyone. We're waiting for all repairs and necessary works to be completed accordingly. And obviously Ian McIntosh goes back and advises that he's been in attendance and there are individuals in the property at that stage. The owner makes no attempt to deal with the illegal occupants at that stage. Closing order eviction notices required to be served on the property by the council. And a neighbour contacts the council on the 2nd of September to advise that the family had moved out. It was only at that stage that the council took steps to secure the property. And this was done on the basis of safety for both individuals in the close and the property itself. If I can refer you to Anne's statement, she deals with this in paragraph 10, sorry. Obviously, the Govan Hill area is a jointly funded property area for the council and the Scottish Government due to poor property conditions and management issues experienced over the years. She points out from her knowledge that a locked door has not acted as a deterrent when a flat has become vacant, as on several occasions, flats in the area have been occupied or illegally let. Because of the lack of action by the owner of the property at that stage, the council took the decision to install those security measures. It was really to add an additional level of security for peace of mind of the residents in that block, but also to the landlord that it wouldn't be broken into again. Since the door has been put in place, so 2 years after Govan Hill Limited owns the property, there has only been, I think, 4 requests for access to the property. Mr. Thorburn did go out and see the property in October 2021. And at no point in time have the council ever denied access to the owners. The usual practice would be for the property to be secured and the owner to reimburse the costs, and they would get the keys for the door, but that didn't happen in this case as the invoice was never paid. So there hasn't been any attempt by the council to restrict access to the owners. They have been allowed access at any point in time, and they had free access from January 2017 until September 2019. There was really safety concerns for that close and the property itself that led to the council putting on the secure door. Since that stage, I don't believe any contractors have been asked to gain access to the property. I know Mr. Thorburn attended in October 2021, but I believe he attended on his own. Last week, I think it was on Friday, Mr. Zubar, Mr. Thorburn, and Mr. Chowdhury were allowed access to the property, as obviously they are allowed access to the property. I don't believe there's any contractors engaged at that stage to review the property and see how much work requires to be carried out. So I think it's not true that we are in any way benefiting from a secure door being put in place. It was simply for a safety aspect that the council was worried about. And before the secure door was put in place, I don't know if Mr. Thorburn can advise us, but there is no information in front of us to show what repairs have been carried out, who has been out in the property. The only time we've been told that there is works being carried out in the property, it appears that there's a family occupying the property, and we require to serve closing order eviction notices because the owner takes no steps at that stage. And so it isn't clear. And since the door has been put in place, we're not aware of contractors going out and attending the property. So I don't know how Mr. Thorburn would say that there has been any restriction or that has prevented them from carrying out repairs, because it isn't clear from the information we have today that there was any attempt to carry out repairs at any of the times that the owners attended the property or directors or the company secretary attended the property.
Yeah. Well, the specific question I think was asking about the legal authority to take these steps to exclude him. I think his question was about the principle, and we maybe speak a little bit about the implications of the detail. I don't know if you're able to just help me and him with an indication of the presumably legislative basis in which exclusion of him from the property, subject obviously to individual arrangements from time to time, would work.
Yes, so Section 85(1) of the Housing Scotland Act 1987. I will just read it in full.
Thank you.
General duty of local authority in respect of houses not meeting tolerable standard. 1. It should be the duty of every local authority to secure that all houses in their district which do not meet the tolerable standard are closed. Emphasis, are closed. My emphasis. demolished or brought up to the tolerable standard within such period as is reasonable in all circumstances. I'll stop here. The other section talks about the period that is reasonable for the purposes of the Act. What we are saying is there was a closing order served on the property under this section. So we fulfilled our duty to serve a closing order. That closing order was not complied with on several occasions. We would argue that this section of the 1987 Act enables the authority to secure the flat until such time as the owner complies with the closing order. And that is, again, in the context of all other obligations that the local authority has in terms of public safety and other points. But
Yeah.
and again, emphasizing that at no point access is denied. That is only to make sure that the property is not occupied for, illegal activities, antisocial activities, and so on, any illegal activities.
Okay. I'm looking at the closure order and I'm navigating across the closure order to the legislation, and it certainly references the property not meeting tolerable standards. I'm skimming down to see the basis. It's there's a set of circumstances there on page 6. But going back to the legislation, I think section 86 has a list of circumstances of which it's explained what is meant by not meeting tolerable standards. Which part of section 86 was relied on for the closing order? So that's the definition of not meeting tolerable standard. It's section 86, subsection 1.
Apologies, I will have to have a look at the closing order to see exactly.
Yeah, sure. No, I'm doing the same. I'm navigating across one from the other. It's your production 7. I can summarise. It's relatively short. There's fire damage present at the property, floorboards showing signs of movement, roof beams, unsatisfactory mechanical ventilation in internal kitchen, unsatisfactory heating system, unsatisfactory supply of hot water in bathroom. Unable to confirm whether electrical installations complies with the relevant requirements, unsatisfactory supply of hot water to the kitchen. It notes also that the property doesn't have a smoke alarm, and there are concerns over gas safety. And the first right bedroom door is stated as hanging from the door frame. I know it's quite difficult to cross refer different documents, but that's effectively what the closing order says. So I'm looking then at how that reads across to section 86.1.
Can I just clarify the section you're referring to? Is it 85.1 or 86?
I'm looking at 86.1. The reason I'm looking at 86.1 is the 85.1 talks about the power to close where the property does not meet tolerable standards. And I'm looking at 86.1 because that defines a house that meets tolerable standards.
Apologies. There's several definitions of a house meeting tolerable standards, and in this one, it seems that it doesn't have an adequate pipe supply of wholesome water available within the house. Sorry, section 1D.
Yeah. Appreciate Mr. Thorburn very probably doesn't have the section before him. So
Actually, I have got section 85, 86 before me. Another
good.
managed to
That's okay. That's fine. I'm glad. I'm glad to hear that.
And then in section G, in the case of a house having a supply of electricity complies with the relevant requirements. And obviously there's several that refer to unsatisfactory supply of hot water in the bathroom and electrical wires trailing over the wash basin and unable to confirm whether the electrical installation complies with the relevant requirements. Satisfactory facilities for cooking food within the house. And I think there was unsatisfactory mechanical ventilation in the internal kitchen. And obviously K was satisfactory equipment installed for detecting and giving warning of carbon monoxide present. I don't think that was in the property.
Well, yeah, that's only effective from the 1st of February this year. That was only added relatively recently. So
It's the office advisor.
They were the more recent ones, so right, so it's just other
Yes.
relevant information.
yeah, I mean there are others, but as I say, that one's been added after the closing order. Okay.
You should specify.
Mr. Thorburn, I mean there's been an explanation there of the kind of factual background and a reference to those sections. Is there anything you want to say further, or any questions you have further on what you've heard?
Oh, very much so. With respect, the council has not answered the question. I think that I thought was what you were putting to them after they had given their first response. Now, section 85, general duty of local authority in respect of houses not meeting tolerable standard. It does use the word secure, but it's not in this context. It shall be the duty of every local authority to secure that all houses in their district which do not meet the tolerable standard are closed, demolished, or brought up to tolerable standard within such period as is reasonable. Now, that, as I read it, is a legal provision. That gives them the right to grant closing order, which is a thing like a court order or a kind of legal demand, as it were. And that's what the closing order did. Now, in her explanation, the lady mentioned that the council found it necessary to go forward and serve eviction orders on the persons they say were in occupation. Now, that I assume that was something that they had the right to do as a power that was consequent upon the existence of this closing order. What I'm saying is that, yes, they did have powers, but these powers did not include the right to go into the private property of a third party, the owner of this subject property, and arrogate to themselves the right to say who gets in and not, and on what terms and conditions. And it's a minor point, perhaps, but I think still important. She ended by saying they made no attempt to restrict access. I would say to that, simply having that security in force was a restriction of access. However they used it, they arrogated to themselves this restriction of the owner's access to its own property. And they dance around between the different benefits, either for residents, either for the landlord, either for the property itself. If there were a clear power, they would have had to identify what prompted, what triggered the exercise of the power and what it was trying to do. And we, as an owner, would have had a right to challenge that. They haven't identified any such source of power, and as far as I can see, there is none. But if they still think that they had the power I would repeat the question. Where do they find it in the Acts?
So your point effectively is in section 85, the reference to secure is a reference to an outcome.
Absolutely,
not a reference to the ability to lock up property.
Absolutely. It's just the grammatical understanding of the sentence. It is not to secure anything. It is to secure that something happens.
Yeah, it's to secure that. It's the important bit. Secure all houses. Okay, council.
Did I mention the emphasis? I'll let my colleagues speak, but just to complete this discussion now, the emphasis is not on secure, it is on closed. The houses are closed.
To which my response is yes. You served the closing order in terms of that section, and I think other sections as well. But that's where you would say that was your obligation to take that act, and the condition of the property and so on is your justification. That is quite clear and understandable. But the further step of putting physical, the metal structure onto the property, that is a totally different type of act, and it requires authority. And I cannot see any basis for the council having that authority in this case.
I appreciate, Mr. Thorburn, you have a difficulty in the sense that you acquired the property in 2017 and the closure order was 2015. So the company wasn't the owner at the time when the closure order could have been challenged, presumably. I don't know if you know anything about whether it was challenged previously. Neither you nor Mr. Zubair may know the answer to that question.
No, I can understand the interest. All I would say is I don't think that is strictly relevant to where we stand at this point. We're not in this objection questioning the actual closing order. We're questioning the conduct of the council in preventing our access or restricting our access.
I understand that. Indeed, that's absolutely right, of course. That's the relevance of that to the order itself is it's a different process. It may be sensible, therefore, to move on. And the next question is, as I'd understood it, and I appreciate you said at the beginning of your comments there that you see the objection more as being unnecessary rather than premature, and I understand that. I think it's unnecessary is the general point. I had taken the prematurity argument and described it as such because my understanding was that your point, and this may also tie in with the ability to get in, is that actually you were going to be doing all this stuff. You plan to do all this stuff. And it may well be that you've been constrained or restricted in doing so because of access issues. But I wonder if we could move on to that point, which is I described it maybe slightly inaccurately as prematurity, but essentially I understood this part of your argument as saying that you have plans, that you were intending to do this. You haven't done it yet, but you were intending to do this, and therefore it's unnecessary. In my sense of the concept of prematurity, is that fair? I mean, I'll let you present your argument in what way you think, but that's what I took from it.
Yes, that's absolutely right. I certainly wouldn't dispute any of that. And as I kind of did mention in passing, that the restriction of access has had important practical effects. Okay, if I can slightly divert, the council have repeated their factual comments a number of times, and one of the comments they make is that there was no sign of any work going on. Now, having read the emails between the council and Mr. Raza, he was explaining that the keys were given to a gentleman or couple or somebody, so that they could do some painting work. Now, I'm not going to seek to justify that as a wise move, although in theory, if that is correct, it is something that he was perfectly entitled to do. He certainly denies in that exchange that there was any permission given for residents or even any expectation on his part that these people might actually end up residing there. But I think that from the company's point of view, work was actually being planned and instigated. I think there is some support from that, from what was visible at the site meeting yesterday. I mean, there was some material lying around. There was a radiator, which I think was still wrapped in polythene, so it's a new item that had been brought in. I think if you recall, as we were in the kitchen looking at the cupboard in the corner, and we identified that there was shelving above and a blocked area below. But between that cupboard and the window, there was actually a new gas boiler installed. That, I'm told, I'm not really wanting to give evidence, but my understanding and information is that that boiler was installed in about 2019 as part of the effort. I wouldn't put too much emphasis on the word, but there was an effort, however unsatisfactory, to get some work going and do some work on the house. So I certainly would want to challenge this claim on the part of the council that there was a complete absence of anything from the owners. That we certainly do not accept.
Can we ask, so before you go on to your next point, actually you finished that point just now, I was going to ask that question actually, a question around that, and I'm referencing now your objection on the 18th of March, and it really is in your section about the history, you say that the properties remain unoccupied since the damage, and I think there was fire and vandalism had caused damage, and it says the owners undertook a comprehensive programme of repairs, but this remains uncompleted. Now you mentioned some of the stuff there, and in the next page you go on to a bit more detail. What I'm interested in is, what we saw yesterday was certainly some evidence of things that were there, and equipment and boots and various things of people to be doing work. But maybe describe it as a comprehensive programme of repairs, albeit uncompleted. It struck me as maybe not quite right. And you indicate new windows have been installed, and I certainly was aware of at least one window at the skylight with the pigeon infestation came. You mentioned plumbing and heating systems, and that there are new materials on site ready for use. Is your reference in your objection to new materials on site, is that what you mentioned a moment ago about materials that you indicated were on site yesterday?
Yes. To be honest, I think my recollection from October was of slightly more material being there, and I mean, I wasn't aware that a company had been in. I think in January we now have the Hanlon people. We have an invoice from them, who they both cleaned up the pigeon droppings, but they also removed various articles, and I think some materials that were possibly there for work have actually been removed. They maybe weren't identified as being intended for work. But I think there is certainly less in the flat now than there was when I had seen it in October of last year.
Sure.
But I think it's more the principle that we certainly. There's certainly not been a lot of work done. I'm not trying to claim that there is. I think we can discuss the general scope of what is required. Now, I've been aware of a number of other properties, I think in Govan Hill area, which have had major structural issues where foundations have been found to be collapsed, and tens of £1,000s worth of work was needed, and this was way beyond the resources of individual private owners.
Yes.
Now, I'm not a surveyor, and I've perhaps been a little bit bold in the comments I have made. I don't want to be exaggerating, what I can properly say here, but I think it is a fair comment that the general condition of the building, I've no doubt that it would be useful. Again, I hadn't been aware that there had been recommendation for a structural engineer to have a look at the roof structure. Actually, that was something that had occurred to me, knowing that there had actually been in the past some fire damage to the common roof structure. And I think that we would have to accept that that is quite a sort of reasonable suggestion that should be looked at. But there's certainly no obvious damage to the building, and that fire, I'm told, was quite some time ago over the years. So it's really just out of particular caution that we might have to do that. But the remainder of the work that needs to be done, it's not a small job, but it's not a rebuilding job. The basic structure seems to be perfectly sound. The building is sound, as I think was explained yesterday. There was a refurbishment scheme on the tenement about 10 or so years ago, and,
Sure.
and we could see the effect of that. So the comment that I make here, that what is needed was within the capacity. Yeah, the scale of the works is well within the capacity of an owner of moderate means. I would say that is a fair comment, that there are no extraordinary resources needed here. Whereas in other cases, it makes much more sense for the limited public resources that there are available should be directed into cases where that actually can make a real difference. That is not, we don't find here at all. I think the council in their literature say CPO should always be a last case. Again, sorry, I was searching my mind for a comment I was going to make.
Sure.
If they're correct in saying that there were people living there, whether it was with the encouragement or acquiescence of the owner at the time or not, there is no question that these people got access to the flat from the owners. It was not a case of them breaking in. That may not have been the case with the cannabis, but that's the only occasion when there has been, or could have been, I don't know the facts about behind the cannabis, whether it was there was any kind of complicity or not. I assume not, because I'm not aware of any proceedings having been taken. In fact, it was suggested to me that actually it was the owners themselves who alerted to the police at the time that there was a cannabis, but I can't say that from sort of very reliable information. But the occasion when we know that there was somebody, or we believe there was somebody there who should not have been staying there, it was somebody who got the key from the owners for the purpose of doing some work, not by breaking in. So the suggestion that you needed to secure the property from third parties, I think is pretty weak. Again, we saw there was a door entry system. I think Mr. McIntosh had to ring one of the other residents to get access before we got into the common close for the inspection yesterday, the site visit. So I think they've got very weak ground, even for the kind of justification, quite apart from the legality of it. The main point is they may well have felt it was a reasonable thing to do, but if they did not have the powers, as I think they didn't, they were not entitled to do it. And even more so, they are not entitled now to benefit from the obstruction that it was to us, the owners, and promotive CPO.
Thank you. Now, I'm conscious I said I'd break at 11:30, so we're a little bit beyond that, and your cup of tea's arrived. I saw it arrive in the background there. I would say you need to have a chance to be doing that. What I intend to do is just have a short break just now and come back, maybe take a 10-minute break for now. I'll carry on with you, Mr. Thorburn, just a little bit longer after that before we go back to the council. And what I'll say before we get the break, to give you a chance to think about this, two thoughts came to my mind when I was listening to your presentation there and what you're saying a moment ago, is one of which is on the question of the planned repairs and planned improvements. Is that what we don't have? We saw a little bit on site yesterday, but as you say, maybe there was something more that was there before. What we don't really have is a program of works. We don't have, we don't have documents that sort of show what your plans were. And the second thing is, I know you've only been the owner since 2017, and there've been issues prior to that. But the argument that it's a relatively modest job. It's to a certain extent a slightly double-edged argument, because the question might arise, if it's so modest, why hasn't it been done? Bearing in mind the length of time and as I said, the absence of a kind of schedule of work. But I'll leave those questions hanging, and maybe we'll adjourn till 11:50 to let you drink, or in other cases, collect a cup of tea or do anything else you want to do in that 10 minutes. But we'll convene again at 11:50 and go from there. Thank you.
Thank you very much.
Right. I don't know if you can hear me, Mr. Thorburn. I can see you, but not
Yes.
Liz yet.
Can you hear me?
Rejoin, that's fine.
Yes.
That's a different angle of a council building, but that's all fine.
Yeah, here as well. Yes.
That's all good. Right. So hopefully we're all duly refreshed in
Thank you.
various things. I'd left you with a couple of questions, Mr. Thorburn, just to reflect on, and then there may be other things. There's a couple of other things that will come to my mind. Then I'll invite the council to comment on I think both aspects. I mean, in practical terms, I think the sort of the items on the agenda are being rolled out to a certain extent. But I'll let you carry on with your presentation now, duly refreshed.
Thank you. I would just comment that Mr. Zubair has popped out. He's gone to the toilet.
All right, okay. Well,
He will rejoin just in a few moments, but I'll just carry on in the meantime. The second point first. In a way, there is a contradiction between calling it comprehensive and also a relatively modest job. But I would suggest that both are actually compatible. Comprehensive in the sense that, yes, it needs new electrical installations, new plumbing, it needs new doors and complete redecoration and so on. But the actual skill sets that are required for that work are all fairly common trades that are available. There's nothing particularly difficult about it, but it covers the whole property. I mean, the whole property needs to be subject to this refurbishment.
Sure.
But
Yeah.
As I pointed out earlier, in my view, that it is within the means or competence capacity of an owner of moderate means. Now, I did take the opportunity to discuss with Mr. Zubair here what he would propose to do with the property. And he acknowledges that his proposals will require a building warrant because he wants to relocate not the kitchen, but the bathroom. And that will involve ventilation and so on. So he's aware that there is that sort of formal process of obtaining a building warrant. But subject to that, he is confident that with his skill set and his contacts in the building trade, the people that he works with, because he himself is involved in the building trade, he can actually have the whole property transformed in 3 months from having that paperwork that gives him the authority to go ahead. And he's, I think, quite comfortable about giving an assurance to the council, if that was part of some arrangement, that he would do that. I mean, he's now back and he can.
Yeah, I see that.
He's available for any questions that you might want to direct. He, in fact, when we were discussing it briefly, his approach is actually quite a radical one. His view is the job is simpler to work from a blank canvas rather than do a sort of patch-up job. And he would propose that all the basic finishes within the internal finishes are replaceable in his view, and that would get the best finish, but actually would simplify the job, that you would be creating effectively a new interior, remove what is there, which is it's more than served its time. I think we can all agree on that. And that the job of replacing that is basically a fitting out job and is perfectly achievable within a 3-month timescale. Is that of any?
No, that's very helpful. I mean, I suppose the question from my point of view, and I know that he himself has only been a director since the beginning of the year, but the property was subject to the closing order in 2015. I think you've been in 2017. So I suppose the question is, hearing all of that, and I'll ask a more detailed question about it in a minute, is the question of why hasn't that been done before now?
I'm not sure. Well, as I said earlier, I got most of my information from Mr. Raza, who acquired it in 2017 with Govan Hill. So my knowledge of the history is limited by his knowledge of the history.
Sure.
And so it's there's a bit of archaeology involved here. I mean, but again, looking at how I'd phrased some of the earlier parts, the description and history in the objection, I was going back to what I had been told by Mr. Raza and also what I had deduced from visiting the property in October and trying to work out. So I can't claim that is, fully definitive in terms of.
Sure. So how long have you been company secretary for?
I have actually been company secretary since the company was formed. So technically I have been involved throughout the period of ownership. But in practical terms, my involvement in this property really only started, I think it was about the September of last year. And I think that was prompted by, well, it may have been prompted by communication from the council to Mr. Raza, but certainly it was prompted by his communication to me to assist him and see if we could get things moving.
Yeah, okay. And what sort of timescales are you suggesting that a building warrant could be applied for? Obviously, it's not within the applicant's control for when it be granted, but the sort of timescales for making an application.
How long would you need to apply a building warrant? Yes, you'd need to get a surveyor or somebody competent to examine the property, prepare the plans, agree with you what you needed
Within 1, like 2 weeks.
It's 4 weeks.
Yeah, I'd maybe inclined to say 4 with Christmas coming up. I suspect.
Absolutely, yes. Yeah. Working. Yes.
Okay. And one of the questions is in my mind in terms of my reporting duty, and I'll be reporting ministers, and ministers will need to think about my report, and these things don't always move particularly quickly. But your argument is that the ministers should refuse the order pending this work being done, the building warrant being sought for, obtained, and then within a 3-month period implemented. So my question, I guess, is what confidence could ministers have if they were to refuse the order now, and it's not for me to decide, but if they were to refuse the order now, what confidence would ministers have that this aspirational time limit is going to be met, given that since the closure order in 2015 and the acquisition by the company in 2017, which is now 5 years ago, that nothing significant has happened?
Well, Mr. Zubair he has not been involved before. He has a different background. He is actively involved in the building industry. That is his work day to day. So he has the skills, he has the knowledge, and he has the contacts. I would say he is a kind of motivated owner, certainly more motivated than appears to have been the case in the past. I think it's not really appropriate for me to comment on previous owners. What I would need to say is that this, I think, is all conditional on, the council's lawyer effectively picked up something that's in Miss Moran's statement.
Sure.
She made the comment about the normal practice would be for the owner to be asked to pay for the cost of the security arrangements. And once that was done, a key would be given to the owner. Now, I was very surprised to read that in Ms. Moran's statement, because it has never been suggested, even now I have not seen in any of the papers any suggestion that that would have been offered or available. And I would suggest that, particularly in Mr. McIntosh's involvement, everything that he has said contradicts that point. But if it's possible to keep this procedure on, shall we say, a more positive note, I understand that what I am saying is serious criticism of the council. What I'm not saying is that it was deliberate. I'm perfectly ready to accept that there was a sort of mindset that, yes, we can do this because it's necessary. And that just as Mr. Raza and I assumed that the council had powers, that even although these ladies and gentlemen are dealing with things like this day in, day out, and you would expect them to be fairly familiar with what the limits of council powers are, I do not want to exaggerate that point. Now, I would like, as a sort of minimum from this hearing, the council to go away and let us know, if there's not a determination about it in the course of the hearing, that we should now have a key that they cannot justify excluding us from our own property. Because that is an essential element to any timescale. We can't give any assurances if we do not have control of our own property. Now, there's no way that Mr. Zubair is going to allow anyone to come near the property who could be suspected of coming with a sleeping bag and dossing down and making it a home. That is just not going to happen, and we can give any assurances that may be required for that. But I mean, taking the kind of risks that are being implicitly alleged, it just makes no sense. It would totally undermine our position, as some of the less than wise decisions that have been taken in the past have clearly undermined the previous owners. And we have to learn that lesson and take the consequences of it. And I'm prepared to say that, because we come to this hearing as serious people. Our integrity is important. We do not want to, make promises or give assurances and then go away and ignore them and break them. I have known Mr. Zubair for quite a number of years, and certainly from my assessment, I have no hesitation in putting forward views that I'm sure he holds sincerely.
Okay, thank you. I should just say that as I said at the beginning, my role is as a reporter, and I'm not making a determination today, and I'll be listening to the arguments and then completing my report. Maybe there'll be closing submissions and the like. So you can rest assured that I'll be making no determination today. It will matter for ministers on consideration of my report, whether to seek to confirm the order, and after that, as I think as the council have said, there will be a process of going through an additional degree of formality that's required if the confirmed notice, if that's the outcome, is given. There's then a vesting process that means title transfers across to the council if the CPO is permitted. So there's a bit of process to be gone through, but I can assure you, I'm not going to be making any determination today. I've got one more question, and then I'll pass over to the council, because there's a number of things that are arising from that. And sorry, lastly, in relation to the fact that I'm making no determination, there is absolutely nothing to stop you and council officials continuing a dialogue after today that doesn't involve me. This hearing is for the process of the CPO, and indeed it's possible. Indeed, I would encourage people to continue to talk to each other. Talking is good. So I'd say that. My other set of questions in relation to this, Mr. Thorburn, they're partly answered this, but I'm just interested in the question about direct sale to Govanhill Housing Association. I know there's been a bit of toing and froing about discussions and negotiations which have never really got off the ground. It'd be useful from my perspective just to get a sense from the company of its intentions. I mean, has it been interested in rather than repairing, and I heard what you just said, and renewing a conveyance to the housing association? Is that not in contemplation? Was it once in contemplation but no longer in contemplation? I wonder if you just give me a bit of colour of the sort of the history of that element of things, because that appears obviously in the precognitions from the council.
Yes. Well, again, my understanding of this is that, yes, it was in contemplation under Mr. Raza, and there was, I'm not sure if it was a formal offer, but certainly I think a figure was put on the table.
Yes, there's a document submitted, put on the table for, I think, £80,000 was the price that was offered at that point. That was a district valuer valuation. District valuer's office is part of HM Custom and Excise as an independent valuer.
Yes. Yeah. Okay. That certainly confirms the figure that I had in mind as having been mentioned, but I wasn't sure about it. And his view was that was not a reasonable figure that he wanted to go forward with. And to be honest, again, I'm kind of mind reading Mr. Raza, but I think that part of the process of consideration that resulted in the takeover to Mr. Zubair was his feeling that it was unlikely that an agreement might be reached after that with the housing association. Now, I think Mr. Zubair's position is slightly different. He is what he's said to me is that his interest is as a long-term investor, and he feels that he has the skills and capacity to make this into an attractive property, but and one that he would wish to retain within the context of the local private housing market. So his preferred approach would be to complete the renovation, the refurbishment, go through the procedures for landlord registration, because obviously that can't be done with the property in its present condition. And again, that's another incentive to him not to take any risks that would affect his approval by the authority. Because the same council is the housing regulator as deals with the issues we have here.
Okay, thank you. And I think the council did say that landlord registration expired on 1st November 2021. I think your answer just now suggests that that's right. That needs to be restored in due course. But it's
yes. To be honest, I'm surprised that it actually was registered, because I don't think the property, if what's being said about it, what I've seen of it, it was actually in a condition to be registered. So it's certainly better off the register on the register.
That'll need to come back.
Okay, yes.
That's fine. Okay, I'll move just onto the council just now. First of all, looking to lawyers for comments, but I noted there were a couple of comments there addressed to Mr. McIntosh and Ms. Moran, both about the evidence they've given, but also about the questions of future dialogue. So I'll just maybe get legal responses just now, but you may want to bring in those officials at the appropriate time in responding to what you've heard over the last half hour or so.
Firstly, with the kind of history of the property and what has been carried out. I know Mr. Thorburn says he really only became technically aware of the property in September of last year, and he has obviously been the company secretary since January 2017. And I don't know what communication there was between him and the owner, but I would assume he had some awareness of this property being held by the company at that time. Really, there's just been a history of a lack of action by the current owner and the previous owners. I note that we've been told today that Mr. Zabir says that it will take 3 months from the building warrant to get all the repairs done. And I think this has already been mentioned by yourself, Mr. Hackett. But if it was only going to take 3 months to carry out all these repairs, why was it not done within the 3 months between 2017 and 2019? The company has had sufficient amount of time for the owners to engage and to bring the property back up to a tolerable standard. Since Govan Hill Limited took ownership of the property, they'll have been aware that a closing order was in place. They were also a dormant company since 2017. It's only been more recently that they've become an active company again. And I don't know if that would have any impact on their ability to carry out any works during that period. Reference is made to comprehensive plan in the objections. And I think even at this hearing, we still don't have a comprehensive plan for what repairs are going to be carried out. There has been access given to the property. After 2019, obviously, Govan Hill had access to the property in 2017 and were able to go out with contractors and prepare any schedule of works was required. That hasn't happened since 2019. There hasn't been any access involving contractors to go out and set out what repairs are required at the property. Mr. Zabir, I understand he has only become a director since, I believe it's April, the end of April this year. But what steps have been taken since April this year? Mr. Zabir went out and saw the property for the first time last week on Friday the 16th. There was no contractor out to give him any quotes for the completion of works that would be required. So it is hard to see what evidence there is today that repairs will be carried out. Obviously, now that we're nearly 6 years after Govan Hill Limited have taken control of the property. And I think I've already raised this before, but Mr. Raza is still a shareholder. From the information we have from Companies House, it's unclear whether the same actors are involved in the property now or whether this is a fresh start with Mr. Zabir as a director, and he is listed as a sole shareholder at this stage. Just focusing on after Govan Hill Limited became the owner of the property, because I know Mr. Thorburn will say that it was previous owners who never took action at the time of the closing order, but there has been an awareness the whole period of the ownership that there was work requiring to be carried out and hasn't been carried out. Obviously the district valuers, I know Mr. Raza had said that he wasn't happy with that figure. That's really not part of the order today. Any compensation would be dealt with at a later stage, so that would kind of be a separate procedure, not something we really need to focus on today. And I understand the comments made by Mr. Zubar, but given the history of this property and that no action really has been taken since he became a director, it's hard to be assured that works are going to be carried out on his timescale before April next year. And I think, was there 2 points to be made with regards to
Yes,
I think it was
there's a question of it was with Anne's definition in paragraph 10. I don't know if she wants an opportunity, and Mr. McIntosh has mentioned as well, whether she wants an opportunity of a comment and rebuttal of that. There's a question about the access to the property, what were described as normal arrangements that Mr. Thorburn was questioning.
Yep, I'll answer that.
Thank you.
As I'm just looking at my notes on this, the owner was advised, a colleague in For 2019, that we would look for the cost of the road to be replaced in Northern Council and access to the available.
I can't
No,
hear
just
you.
hold for a
Can't hear
second.
you.
That's, you're not coming across very clearly. If we lean forward to, and I think neither.
Okay. I'm just looking at notes that I've got on this, and in September
Okay.
2019, I can see that the landlord was advised at that point that we would be looking, that we normally look for the cost to be reimbursed. Sorry, apologies, it's not. Oh, hang on.
It'll take time.
Yeah, it was September 2019 at the point when we were asked to clear the food from the property. If I remember right, it's Mr. Raza who would still be the landlord at that point. And he was advised that normally we would ask for the cost to be reimbursed and we would provide the keys. Just to stress that at no point have we ever refused access to the property. We would always, it's not our aim to prevent a landlord from the property.
I think I have seen emails referring to the figure for the cost. I have seen nothing about offering keys. If you have paperwork for that, can you identify it? Because that is a crucial point. All the paperwork we have, access is conditional. It has never been offered to have the keys.
Something. Access, it was not conditioned. Access was granted at any point the owners contacted the council. The only question was having the key to the door. But access was granted at absolutely any moment. Recently, we've asked for 24 hours notice just because it was so near these proceedings, but access was never conditioned.
Well, you're saying two things that are contradictory. You're not answering the basic point. By holding the keys, access was always conditional. It was conditional on your consent, and that consent was always subject to conditions.
But the consent would have been withdrawn. If you came and said, we want access, we couldn't have said no. So there was no consent required on
But you refused to give us the keys. That's the basic point.
Oh, we allowed you access.
But
I suspect we're talking two different things. Mr. Thorburn's point, I think, is the point of principle as to it's Governor Hill's property, therefore they should have the keys. And so when they're held by the council, they're not held by the owners. Whereas what the council are saying is that's true, but at no point was access refused. If you ever asked for it, arrangement to be made, but it had to be made to the council because the council held the keys. Is that effectively it?
It's both principle and practice, because I did comment earlier that when I reported back to Mr. Raza after my visit, and we shared the photographs and so on, he then spoke to a number of contractors, and it was always a problem with them that we could not just give them free access as and when they required it. So although principle is important and crucial, there are practical consequences of us not having the keys. Now, I'm not sure if that was suggested just now, that the keys could have been shared. That might actually be implicit in the comment that Ms. Moran makes in her statement at number 11. The normal practice would be for the property to be secured, the owner to reimburse the cost, and then they would get the keys to the secure door. Now, that doesn't quite make clear whether each party has keys or if the keys are just handed over. But at least, even if it's the first, both the council retain keys and the owners have keys, at least then they have free access and they can come and go when they require. That was never granted. Okay, on principle, shared keys it does offend the principle, but it would not have had the same practical effect, and that is important.
Just on that practical effect, I wasn't sure whether in the period of the Governor Hill Limited's ownership, which is 2017, I wasn't sure whether in practice access was sought and given on 3 occasions or on 4 occasions. I'm trying to get my head at the precise number. The precise number itself may not be terribly important, but there have been occasions, I think, when the access has been asked for, including, as has been said, as relatively recently. And Mr. Thorburn, you mentioned this at the site inspection yesterday. In fairness, you said you'd been there in the previous 7 days. So is it maybe, I don't know if you can precisely say whether 3 or 4, but it's presumably of that general order of the number of times keys have been sought.
Yes. I think there were discussions in the September, October 19.
All right, 19, yeah.
Just in the immediate aftermath of the security being installed.
Okay.
Because, and Moran there mentioned the question of removal of food, because there were emails, Mr. Raza was trying to arrange that. I think he took ill and an arrangement was made and then had to be cancelled.
Cancelled, so I understand.
I'm not quite sure how that was actually resolved. I mean,
and then of course COVID, of course, complicated
and
things.
Then, yeah, absolutely, and then
yeah.
yes. I mean, okay. I can't say that the ownership of the company has been, beyond reproach in its management, but that does not mean that the council are entitled to go and put through a compulsory purchase order. I think before we go to a conclusion, one comment I would like to make. We have still not had a response to my basic question: is what was the authority for putting that security in place? If the council cannot show proper legal authority for doing that, and I don't think they can, my conclusion and reflection beforehand was that they, as a responsible authority, should actually withdraw the order. Now, they may think that's too much of an ask, but I don't think it's too much of an ask to put it this way: that after we conclude today, if they would put their heads together with their senior legal advisors, and if they realise that a mistake has been made, then as a matter of courtesy to you as the reporter, they should let you know that that is the position. And I think that they then should withdraw the order and not put you to the trouble of going through all the process of decision making. Now, that's just my comment, but I want to make it.
Thank you. Okay. I was going to just give people an opportunity now just to say anything final, not by way of closing submissions, but anything more they want to raise. And I'm going to give the objector last say on this. I'm going to go to the council first of all. Whether there's anything that has not been covered for the agenda this morning, or other aspects of this that you would have wanted to have covered before we close the hearing today, and I'll give Mr. Thorburn the opportunity to respond in similar vein just now, and then after that I'll say something about closing submissions. But first of all, the council.
I think really about this secure door, kind of just want to go over, and we're looking at a flat that's within the enhanced enforcement area. Govan Hill is a priority area for both the Scottish Government and Glasgow City Council. There's a history of issues with vacant properties becoming hubs for antisocial behaviour, and I think this property shows what can happen when when a house is left vacant and a landlord isn't, an owner isn't involved in managing the property. This property became a cannabis factory and was reported by the police. Then obviously the explanation given today is that keys were given to someone to paint the property, and they then potentially occupied the property without the knowledge of the owner. And so this is the background we're looking at whenever the property became vacant again after eviction notices were served by the council. And it's in an area where there is a problem with properties becoming targets when they're vacant in the Govan Hill area. And really the council was trying to take a responsible step when there was no response from the owner with regards to the occupation of the flat, or that they were taking any steps to deal with the issues that were ongoing at the property. The effect that the antisocial behaviour and the occupancy of the property was that it was affecting other properties. There was water ingress to the flat below because of the individuals occupying the property. So really Glasgow was simply trying to take a responsible step and safeguard the property so it wouldn't become a target for antisocial behaviour, or be illegally occupied, again without the knowledge of the owner. I think you have to look at the area that the property is in. It is in an area that these are real issues that happen in the Govan Hill area. And obviously that is why there has been a designated priority area for Govan Hill, agreed by it. They have extra powers in that area because of the issues that are ongoing in the area, and they're trying to tackle them. And really that's the responsible steps that they took to ensure that the property wasn't going to be targeted when there was a lack of engagement with the owners. And I think we've already covered it today, but I'll just reiterate again, access was never denied to the property, and it isn't clear that Govan Hill Limited were coming out to try and get a schedule of repairs completed or any works completed. I note Mr. Thorburn raised that in September 2019, was it, that Mr. Waza was trying to contact contractors to get work done. At no point in time were we ever contacted, where any of the principal officers contacted to arrange attendance by contractors to either give quotes or carry out repairs. The council would have preferred if works were carried out. That is what a closing order is there for, to have the property brought back up to a tolerable standard. We've got to this point because no action has occurred within the last nearly 6 years. And this seems to be now the only option for the order to go through under certainty that the property isn't going to be left as an empty home and will become a valued resource for social accommodation in Glasgow. Is there anyone else want to add in?
It's just the only other thing on respect to the keys, just to clarify on that if payment is made for the keys are handed over to the owner, the council do not retain a copy. Mr. Thorburn, we did ask you last year when we met with you about a schedule of works, and as Amanda said, you'd mentioned about getting contractors. You never came back to me with that. Had you done so, by either Ian or I would have arranged to meet you. And on the last point, sorry, I'm taking my bit here, but the council also served abatement notices on you or on Govan Hill Limited, and there was no contact received from you at that point either to arrange access to carry out that work.
Okay. Well, I have explained why we were not able to go forward from my meeting, my visit, to produce a schedule of works. That the attempts were made, but that proved fruitless, or was frustrated. In response to what your colleague was saying, I have avoided, as far as possible, criticising the council. I have not said that they were being unreasonable in the view that they took, although we don't agree with them. We're not accepting all the details, but the desire to have security but there were very stringent conditions imposed on Govanhill over access. I mean, if I can simply read from Mr. McIntosh's email of the 6th of September, I don't have a reference number attached to it. I printed it from the documents that were provided. I think it's on the late list that has about 9 attachments to it.
Yeah.
But it's from Mr. McIntosh to Wasim Raz on the 6th of September. And the discussion about, the family should not have been given access and so on. You will also require to pay the £183, so on. There's nothing related to that payment to the release of keys, but he does go on. I will require you to provide a full list of works that you're proposing. The roof area and top floor of the property is badly damaged. I suggest you instruct a structural survey due to the fire damage and damage caused by the cannabis cultivation. Once I have received the list and seen that the structure of the property is not dangerous, then you will get full access to make repairs. So this totally contradicts the repeated assertions that there was no restriction of access. There was not a denial, but there was a constant restriction. It was always conditional on us coming back, picking various boxes before we were getting. We were never free to go forward with it without coming back to the council. That is the important point. One point that I've been reminded by Mr. Zubair, he did attempt to engage with the council. He, I think, contacted a councillor, and I think one of the ladies present was involved in a meeting, and there was some discussion of the property. Whether or not it was an appropriate way to take it forward is perhaps questionable, but it certainly is evidence of his interest and desire to move forward and to engage with the council, and it certainly contradicts this claim that he has failed to do that.
Okay, right. Lastly for today is the question of closing submissions. Now, I indicated that I wasn't expecting people to make comments in the course of this hearing this afternoon. Parties are entitled to make closing submissions if they wish to. There's no obligation for them to do so, but they're entitled to do so within a reasonable period. I'll speak about the periods just in a minute. The important point, as I know the council will understand, is that a closing submission is obviously an opportunity to draw together the evidence that's been presented. It's not an opportunity to introduce new evidence. The hearing session today, when it closes, is the completion of the gathering together of the evidence for the purpose of this order, which has been the period since the hearing was set back in the summer through till now. But it is an option for parties if they so wish to make a closing submission. Slightly unusually for closing submissions, what I'd ask that parties do if they decide to submit one is, rather than copy the submissions to each other, my case officer, Jane Robertson, who's been in communication with you, you should send your closing submissions only to Jane and not copy to each other. The purpose of that is that means that people don't get an advantage by seeing someone else's closing submissions first and can therefore modify theirs. The submissions will be circulated after the closing date, but you would submit them only to Jane. I am conscious of times since we're moving obviously towards the holiday period, and I'm inclined to say if people are contemplating issuing a closing submission, that these be submitted by the 9th of January. I think that's the Monday. I know some people are back at work the previous week, but I think that's the beginning of the first full week after the new year. So that's what I'm proposing. But if people need more time, Mr. Thorburn, you're looking a bit
No, I'm trying to work out. Oh yes, because Sunday's the 1st, so Monday's the 2nd, and you said the 9th.
The 9th, yes.
The 9th, so it's the second Monday. Yes, okay.
The second Monday, yeah. I mean, I say some people might be around the previous week, but obviously the how much work you need to give people a chance to give some thought to do the work on them. So I'm contemplating Monday the 9th of January as I close the business that day. So you'd have Monday the 9th, including that date for closing submissions. So from the council, any comments on that?
No, but is it possible, on the basis that this is a more informal hearing, to have another last comment from the council?
Yeah, I'll give Mr. Thorburn a chance to say something back in response to it, but if you have something more to say.
Yes. Following promotion of the order, at the suggestion of the Scottish Government officers who process the compulsory purchase orders, the council contacted Govern Hill Limited in a last attempt to acquire the property voluntarily.
Sure.
A letter was sent out on 19th of May 2022, Govern Hill Limited. And our comment now is to mention that Mr. Zubair contacted the council following the council trying to engage with the owner as a last opportunity. That is all.
Okay, thank
I
you.
mean, what I'm trying to say, it wasn't Mr. Zubair's initiative, it was the council's initiative to get in touch again.
That's fine. I think Mr. Thorburn's explained why they're reluctant to engage in that. And I take the point. This was Mr. Zubair as opposed to Mr. Raza. But Mr. Thorburn, do you want to add anything to that?
I think there's perhaps an element of coincidence in this because, I mean, we know that Mr. Zubair had only just very recently become involved with the company, and this was arrived very much on his arrival, and I think the two things happened together. But he did engage, he did respond. So I mean that has to be acknowledged.
Right. Well, unless anybody else has any further points, I'm going to close the hearing just now with thanks to all of you for your participation, and hopefully you'll get a chance for a bit of peace and quiet in the holiday season coming up. So thank you all for participation this morning. Okay, the meeting's now closed.